Good afternoon. Hi, I'm Kelly Voss. I'm president of the Washington Council of Lawyers, and I can truly feel the anticipation in this room, and I confess I'm very excited to be here myself. On behalf of WCL, I'm honored to welcome you to this year's Summer Forum. The Forum is one of WCL's finest and earliest traditions. We've been hosting it since 1978. The goal then was the same as it is today, to inspire each of you to be the kind of lawyer who works to bring our society closer to the ideal of justice for all. Today, we do not need to look much further than this stage for such inspiration. We are thrilled that Justice Ruth Bader Ginsburg is joining us to reflect on her experiences and the importance of public interest law in our society. Justice Ginsburg entered legal practice at a time when the best jobs were off limits to women, and yet she overcame those odds, making it all the way to the Supreme Court. On her way, she spent a considerable part of her legal career as an advocate for gender equality and women's rights. As a jurist, she's demonstrated that she remains wholly committed to fairness and equality. It's so very special to have you here with us, Justice Ginsburg. Thank you so much for coming.
Thank you.
I would also like to thank Nicole Austin-Hillery, who will be leading the conversation with the Justice. Nicole is a longtime WCL board member, and she's the director and counsel of the DC office of the Brennan Center. Thank you, Nicole. Before we begin the program, I just want to take a moment to talk to you about the Washington Council of Lawyers. We are DC's only bar association solely devoted to the mission of advancing access to justice, public interest law, and pro bono practice. Through events like this one, we strive to build and strengthen a community of lawyers from all sectors who are energized and mobilized to pursue pro bono and public interest legal work. It is our great hope that many of the law students in the room today will return to DC to practice law, and that you'll actively use your legal skills to help poor and marginalized members of our society. WCL stands ready to help you pursue those goals. If you're not already a member, I hope that you'll consider joining. You can sign up online or on your way out of today's program. Before we move on, I do have a couple of housekeeping items. First, in your program, you'll find a bookmark with all of the relevant social media details for today's events. We are live tweeting the event at Wash Lawyers, so you can feel free to join in. Our hashtag is SUMFO17. We're posting on Snapchat at Wash Lawyers as well, and we have a geo filter if people want to post along with us. The second item is that we would respectfully request that the audience refrain from taking photographs or video during the event. Finally, I'd like to turn the podium over to GW Law School Dean Blake Morant for a few words.
Thank you. Thank you so much. Ladies and gentlemen, it gives me a great deal of pleasure to welcome you to the George Washington University's campus for this auspicious event. I first of all want to say I am overwhelmed by the vast number of students all over the country who are giving of themselves to their societies with pro bono efforts. You should know that in many quarters, individuals are asking whether lawyers are individuals that really should invest more in society. You might not know this, but for over 600 years, lawyers have done just that. You don't hear about it very much. And I always tell people, particularly during my time as president of the Association of American Law Schools, individuals are very much unaware that lawyers throughout this country give of themselves in remarkable ways to society. Indeed, the very definition of a good professional who's legally trained is whether or not that individual, in addition to giving great service to their clients, look at opportunities to uplift their societies. And as I see so many of you out here today, and as I look at my own students at the George Washington University Law School, where the class of 2017 gave over 110,000 hours of pro bono service, I can tell you, all of you are not only going to uphold this profession, but you are exactly what this society needs right now, a global society which needs individuals with the type of training that you've received that gives back to society. Thank you so much for what you're doing here. and I'm very much welcome you to this campus and to this wonderful program. I would be remiss if I did not also thank our special guest today, Justice Ginsburg. Thank you so much for lending your talents. I will tell you, ladies and gentlemen, if you want to see an icon, not only of the judiciary, but someone who truly does emulate and symbolize what a true professional is in this society, this is Justice Ginsburg. I am so very grateful to you. And to Nicole, Austin-Hillery, who heads up the DC office of the Brennan Center, again, an individual who gives of themselves to society. So ladies and gentlemen, sit back, relax. You are in for a distinct treat. Thank you so much and welcome.
Thank you, Brennan. Thank you, Dave.
Well, Justice Ginsburg, welcome. This is indeed a pleasure. I have to take a point of personal privilege. It is my birthday on Saturday, and I told my family, guess what I'm getting for my birthday? I start off the week by interviewing Justice Ginsburg, so this can only get better from here. So thank you so much for being with us today. And as you've already heard from Kelly and from Dean Morant, the Washington Council of Lawyers it's actually the District of Columbia's oldest voluntary bar association with the sole purpose of focusing on pro bono and public interest work. And as the Dean said, I think we are in a very historic moment in our country's history, and having lawyers that are dedicated to public interest and doing pro bono work, I think is more important now maybe than ever. And I really like to say that right now we are in a moment where change agents are needed. People who can make the world and our democracy stronger and better. And I have to say, you are indeed one of the most famous change agents that any of us knows. And I'd like to talk to you about that a little bit. Tell us how you came to want to be a lawyer and to want to be a judge. I'm one of those weirdos who wanted to be a civil rights attorney since I was the age of 13, yes. I don't know if you were that weird, but tell us how you came to this point and what made you think this is how I want to make a difference.
How did I become interested in the law? I was a student at Cornell, and my expectation was I would be a high school history teacher. That was a safe job for a woman. I had a professor in constitutional law as an undergraduate, Professor Robert E. Cushman. He wanted me to understand that our country was going through what was not the best of times. There was a huge Red Scare in the country. Senator McCarthy, Joe McCarthy from Wisconsin, was holding forth in the Senate, finding a communist in every corner. People in the entertainment industry were being hauled before the House Un-American Activities Committee and asked to justify some socialist youth organization they belonged to in the 1930s, in the height of the Depression. Professor Cushman pointed out to me that there were lawyers standing up for these people and reminding the members of our Congress that we have a First Amendment that says we have the right to think, speak, and write as we believe, and not as Big Brother government tells us is the right way to think, speak, and write. And also reminding members of Congress that we have a Fifth Amendment that protects people against self-incrimination. So I had the idea that being a lawyer was a nifty thing to do. You could earn a living, but you could also do something to make your community, your state, your country a little better for your effort. So that's what drew me to law. I didn't fully appreciate that in the 1950s, women were not wanted by the law. There was no Title VII, and there was no Anti-Discrimination in Employment Act. There wasn't even the Equal Pay Act. Employers were entirely upfront in saying that they didn't want any lady lawyers in their shop. That was what the world was like in the 1950s. My entry class at law school had over 500 students. 9 were women, and only 1 in that entire class was an African American. So when people complain about the way things are, because I've lived such a long time, I can see, yes, we are far from perfection, but we've traveled a considerable distance.
Justice Ginsburg, I love that it never occurred to you that the profession wouldn't be open to women, that no one had to say to you, yes, you can do this, but you just thought, this is what I want to do, so I'm going to do it. Tell us, is it because of those early experiences where you were facing gender discrimination? Is that what led you to do the work that you did at the ACLU and working on women's rights and gender issues?
Yes, eventually. Not right away, because it wasn't until the society was ready to move in a new direction that an effort could succeed, an effort to change the laws that divided the world into breadwinning men and house and child care women. But at the end of the 60s, the way people were living had changed. I could see it with my own children. My daughter was born in 1955, and I was one of very few working moms in her class. 10 years later, in 1965, when my son was born, it was not at all unusual for a family to have 2 earners. So it wasn't until society was ready to accept that it was time to get rid of these explicit gender lines in the law. I've many times told the story of the turning point brief in a case called Reed v. Reed, decided by the court in November 1971. On that brief, the brief was written by Mel Wolf, the then executive director of the ACLU, and me, with a student team to help us from Rutgers, NYU, and Columbia. On that brief, we put 2 names, Dorothy Kenyon and Pauli Murray. These were women saying the same thing that we were saying in the 70s, but in the 40s, 50s, and even 60s, when the chances of success were nil. Dorothy Kenyon's mission was to put women on juries in every state in the Union. It may be surprising to some of you that in my growing up years, even my law school years, many states exempted women from jury duty. So that was Dorothy Kenyon's mission. Pauli Murray was a woman who was way ahead of her time in many ways. She wrote an eye-opening article. It was called Jane Crow and the Law, in which she pointed to all the laws that were barriers to women who wanted to aspire and achieve and do work that was then thought proper only for men.
I love that they were so strategic in thinking about how we can create some of this change. That reminds me of a quote from someone who heavily influenced my legal education. I went to Howard Law School. And if you go to Howard, Charles Hamilton Houston and his strategies for lawyering are very prominent in your education. And Charles Hamilton Houston is famous for this quote, and I want to share just a bit of it. because then I'd like to talk a little bit about the role of lawyers and what lawyers specifically can do to create change. Charles Hamilton Houston said, and I'm sure you're familiar with this, a lawyer is either a social engineer or a parasite on society. You all heard that. A social engineer is a highly skilled, perceptive, sensitive lawyer who understands the Constitution of the United States and knows how to explore its uses in the solving of problems of local communities and in bettering conditions of the underprivileged citizens. So, this room, Your Honor, is filled with law students, future lawyers, who want to figure out, how do I use these skills and this knowledge to make a difference? How do you see the role of lawyers as social engineers?
I hadn't thought of it in terms of a parasite. I thought of it in terms of plumbers. That is, if all you do with your law degree is you try to turn over a buck, then you are a plumber. You have a certain skill, and that's what you do, and you get paid for it. But if you regard yourself as a true professional, then you have an obligation to help the people who are not as fortunate as you and who lack the skill that you have because of your legal education. So I would divide people into plumbers and true professionals.
I like that amendment. Talk to us a little bit, Your Honor, about some of the cases where lawyers really were using their plumbing and their engineering skills. You look at Brown, you look at Bakke, you look at Obergefell, these cases that changed really the ways in which we live. Tell us a little bit about some of those cases and other cases that you've worked on where you think having that kind of strategic, smart lawyering made a significant difference just in terms of how we live.
We had a great model for how to go about nudging along a social change, and that was Thurgood Marshall, who was very selective in the cases that he brought. Pauli Murray came to Marshall because she had been turned down by the University of North Carolina. This was before she decided to be a lawyer. She wanted to get an advanced degree in sociology. And she was turned down. Marshall said, "We won't take your case." Why? Because it was a possible excuse. At the time, Pauli was living in New York, and University of North Carolina was a state school. So he thought that her case didn't quite fit. And he took the succession of cases to the court, starting with Sweat against Painter, the Texas case, when Texas was finally, the message got through, you cannot educate lawyers and leave out entirely one race. So Texas set up a separate school that was anything but equal. So we started with that, and then another case involving higher education. There were building blocks before he got to Brown. But I must say, I don't think that the real change was Brown. The real change came 13 years later with Loving against Virginia, because we still had apartheid in America, law enforced separation of the races until the miscegenation laws were declared unconstitutional. So Thurgood Marshall was very much a model for us. We couldn't be equal to what the NAACP was in those days because it was the only show in town. If you had a civil rights case, you went to the NAACP. Once the women's movement came alive at the end of the 1960s, there was no one group that could monopolize the business. So there were cases coming up all over the country. some in the wrong order. Still, we tried as best we could to bring cases that would be winners. And you won one, and that was a step ahead, and then you went on to the next.
When you talk about those cases, it's very clear that the plaintiffs in those cases were quite fortunate. You were quite fortunate if you had a Thurgood Marshall who would take on one of your cases. But you know, we have a problem right now in the United States with the whole issue of access to justice. Everyone doesn't have those opportunities. Everyone doesn't have the great case that will eventually come before you. What do you think we need to do as lawyers to better ensure access to justice? You know, you will recall during the last administration, it was a big push by the former Attorney General to try to ensure access to justice for all Americans. And we know that when we look at statistics about people whose cases actually get to go to court and about people who feel as though they're being heard and they have the opportunity to be heard, many people feel as though it's limiting and they don't have those options. What can we as lawyers do to try to ensure better access to justice?
I can think of one, a judge in D.C., he was on the D.C. Circuit, David Bazelon. He launched the public defender office in New York with an excellent attorney, Barbara Babcock, in charge of it. But there was no public defender's office until then. If you see a need and you're able to join hands with other people, let me give you a recent example. The Second Circuit has a lot of immigration cases, and the current chief, Robert Katzman, saw a crying need for representation of people who were in the toils of the immigration laws and either had no counsel or had counsel who were far from the best and were taking advantage of their clients. So he worked with a group of lawyers for some 2 years to set up an office that would represent people with immigration problems. And now there are, I think, over 20 fellows working in that program to provide lawyers to people who badly need them. And this was a man who saw a need and decided that something should be done about it.
And do you encourage all of these young lawyers to look to see where there is the need and figure out what to do about it?
Yeah, I can say that in my life as a lawyer, I gained greater satisfaction from things I wasn't paid to do. I got a salary for.
So that's a great, I think, way to encourage doing pro bono work as well. I always like to remind young lawyers that whether you work for an LDF, and we know there were many LDFs after Justice Marshall and then the NAACP, whether you work for one of those organizations or somewhere else, there's always opportunities to do this kind of work. You know, what would you say to young lawyers who want to figure out, you know, how I can give back, even if in my day-to-day work I'm not necessarily taking on these kinds of social justice cases?
Law school nowadays have many opportunities for students to work in clinics in different areas. And that, I think, has been a great development. I started teaching in Rutgers, the State University of New Jersey, and then transferred to Columbia in 1972. And every year I taught one clinic. I wanted my colleagues to know how important I thought it was. And I remember one time there were some doubting Thomases about the value of clinical legal studies. So there was a simulated constitutional law litigation class, seminar, and then there were my people who were working with me on whatever cases I was doing at the time. And we took the jury case. Then there was a real case from Louisiana challenging the automatic exemption of women from jury service. My colleague's seminar had a moot court competition with the students working with me, and the students working with me did ever so much better, because for them it was real. It wasn't simulated.
I'd like to talk a little bit more about your role in the court right now. You are often touted as the jurist with the loudest voice. I always like to tell people that I'm a lawyer with a big mouth. And you can use your big mouth for good, lawyers. Don't ever doubt that. And Justice Ginsburg, you are often seen as that person on the court who speaks truth to power, who speaks out when others won't necessarily. And for that, you have been given a new nickname. And I have to tell you, Your Honor, I always tell people I am part of the hip hop generation. I was in middle school when the first major rap album came out. So I'm particularly interested in your nickname, the Notorious RBG. I loved Biggie, after whom your name comes. So I'd like to talk about some of the work that you've done, some of the opinions and dissents, more so, that you've written, I think, that are responsible for you getting that name.
Let me say first that my law clerks, when this all started, said, "Do you know where that name comes from?" I said, "Of course I do." And we have something in common. You have something in common with Notorious B.I.G.? Yes, we were both born and bred in Brooklyn, New York.
That's right, that's right.
And I like the way this began. It began with a second-year student at NYU who didn't like the court's decision in the Shelby County case, a case that declared obsolete a key provision of the Voting Rights Act of '65. So at first she was angry, and then she realized that anger is not a productive emotion. She would do something positive. So she took, I think, my statement from the bench of my dissent in the Shelby County case, and she started this Tumblr. And then it took off into Wild Blue Yonder, where even in October, there will be a book about my exercise routine, written by my personal trainer, with illustrations of each exercise.
We'll get to that in a minute. Justice, talk to us about Shelby and about Ledbetter and Bush v. Gore. Again, those are cases where they didn't necessarily go the way you voted, but you had some very strong dissents in those cases. Talk to us a little bit about why you felt as strongly as you did in any of those, that the court was going in a direction that was not necessarily in the best interest of the country.
Bush v. Gore was an exercise in endurance for every member of the court. The court granted review on a Saturday, briefs were filed on Sunday, oral argument on Monday. and opinions released Tuesday. If we had time, the four people who were in dissent would have gotten together and agreed on one dissent. But there wasn't time, so each of us wrote his or her own dissent. Bush v. Gore has never been cited by the court from that day to this. And I think it's just something that happened. As my colleague, Justice Scalia, I would say, get over it. And we did. I mean, it was a tense atmosphere those 4 days. But then when the opinions were released, we went on to the January sitting and did the best we could preparing for it. Lilly Ledbetter's case is a statutory interpretation case. And I had a particular audience, it was Congress. I think most of you know this story. Lilly worked for a Goodyear tire plant. She was an area manager when she was engaged to do that job in the 70s. She was the only woman. And one day, someone put a slip of paper in her mailbox with a series of numbers. The numbers were the pay that every area manager was getting. And Lilly recognized immediately what the numbers meant. The most junior man, someone she had trained for the job, was earning more than she was. So she said, okay, I've had it, I'll sue. And she did, and she won a sizable jury verdict. When the case came to the Supreme Court, Goodyear argued, Lilly Ledbetter sued much too late. Title VII says you have 180 days to complain from the discriminatory incident. Lilly Ledbetter has been discriminated against for years. She's way out of time. And I pointed out what every woman of Lilly Ledbetter's generation knew. That is, if you're the first woman to do a job that up till then has been done by men, you don't want to be seen as a troublemaker. You don't want to rock the boat. And besides, suppose she had sued early on. Inevitably, the defense would have been, it has nothing to do with Lilly Ledbetter's being a woman. She just doesn't do the job as well. But when she's been doing the job year after year and she's getting good performance ratings, that defense is gone. She has a winnable case. But the court said she sued too late. My theory, and it was one that had been used under the Fair Labor Standards Act, was that each paycheck renewed the discrimination. So she had 180 days to sue from every month's paycheck. The tagline of my opinion was, the ball is now in Congress's court to correct the error into which my colleagues have fallen. And in very short order, the Lilly Ledbetter Fair Pay Act was passed with overwhelming majorities, Republicans, Democrats. It was the first piece of legislation that President Obama signed when he took office. It was kind of a replay of an earlier experience I had had. This was before I was a judge. There were two cases involving women who were complaining that they were discriminated against because of their pregnancy. And the Supreme Court reached the remarkable conclusion that discrimination on the basis of pregnancy is not discrimination on the basis of sex. After all, men don't get pregnant. So the world was divided into pregnant people and non-pregnant people. Non-pregnant people included men as well as women. Well, Congress passed the Pregnancy Discrimination Act. I think it was about 78, around then. And it was the soul of simplicity. It said simply, discrimination on the basis of pregnancy is discrimination on the basis of sex. So that was, my hope was that Lilly Ledbetter's case would lead to the same kind of reaction.
When you have decisions that you look at and the court determines this now shows a role or an opportunity for Congress, as was the case in Ledbetter, and as was the case in Shelby County. Many saw that as an opportunity for Congress to go back and take a look at the Voting Rights Act and figure out either a new formula or some way to strengthen the Voting Rights Act. And it hasn't happened.
It wasn't going to happen because what member of Congress would stand up and say, oh, my district is still discriminating, therefore put back the preclearance requirement. That was the problem with trying to come up with a new formula. The Voting Rights Act had very recently been reenacted with overwhelming majorities, and the reality, political reality, was that you weren't going to get members of Congress to say, my district should still be under the preclearance requirement. So politically, I don't think you could come up with a revised formula.
So how do you feel about the court saying, Congress, we're sending this back to you and do your work? I mean, we all are creatures, well, many of us in this room are creatures of Washington. I spend my day hanging out with the men and women on the Hill, trying to move policy reform. When you send things back, or when you say, Congress, this is now up to you to make a change, but we have such gridlock, what sense does that give you that we actually can move forward with some of these reforms?
Well, sometimes you can. And there might be ways to amend the Voting Rights Act, but it would not be picking out different states, municipalities, and putting them under a regime that others are not exposed to. There's one question that hasn't come up that I would like to tell this audience, and that is to appreciate how recent it is that women have become part of the judiciary. Sometimes I'm asked the question, did you always want to be a Supreme Court justice? Well, what Justice O'Connor and I wanted in the days that we became lawyers, we wanted a job in the law. Any job, but as a lawyer, not a secretary. When I was in law school, there was only one woman who had ever been on a federal appellate bench. That was Florence Allen. She was appointed in 1934 by Franklin Delano Roosevelt. She had been on the Ohio Supreme Court. He put her on the Sixth Circuit. I think she retired the year I graduated from law school. Then there were none until 1968, when Shirley Hufstetler was named by President Johnson. Then Shirley became the first ever Secretary of Education in the Carter administration. and there were none again. And President Carter, who is not a lawyer, looked around at the federal judiciary and he said, you know, there's something wrong. They all look like me. That is, they were all white men. He was determined to appoint members of minority groups and women in numbers, not as one at a time curiosities. He had only 4 years in office. There was no vacancy on the Supreme Court for him to fill. But that president literally changed the complexion of the U.S. judiciary by appointing members of minority groups and women in numbers. So he appointed, I think, more than 25 women to federal district court judgeships and 11 to federal courts of appeals. And I was one of those lucky 11. No president ever went back to the way it once was. So Reagan, when he became president, he was determined to put the first woman on the Supreme Court. And he made a nationwide search. He came up with Justice O'Connor, who was then on an intermediate appellate court in the state of Arizona. And a great choice to be first. And now we are 1/3 of the U.S. Supreme Court. And not doing quite as well as Canada, where they had 4 women, including the Chief Justice. But we're moving in the right direction. So when people say to me, when will you be satisfied? When will there be enough? My stock answer is when there are 9 women. No one thought it was strange that for most of our country's history there were 9 men. So that's one change that I find exhilarating. Now it's not at all on. We've had women as chief judges of our courts of appeals. In the 10th Circuit, one woman succeeded another woman. There are many women who have been chief judges of their state judiciaries. And that has been an enormous change.
Indeed. And I was a little frightened, Your Honor, because when you said, President Carter said, I looked at the judiciary and they all looked like me, I thought peanut farmers. But as you talk about women, we can't talk about women in the judiciary and in the legal profession without also talking about other minority groups and the impact that they can have on the judiciary and on the legal profession. What more can and should we be doing to make strides in that area as well? Obviously some of the changes we saw with respect to women, we need to replicate those changes when it comes to opening the doors to other groups whose numbers aren't as great. What recommendations do you have, or what kinds of things do you think we should be seeing in the profession to increase those numbers?
Well, I think they will inevitably increase just because of the composition of law schools nowadays. My granddaughter just graduated from the same law school that I started as a 1L. Her class was close to 50% women and many minority students. So the law schools are doing a much better job than they once did.
Now, as we talk about how the profession can grow by having more diversity in terms of women and minorities, I think that brings us to the question of, all of these lawyers, these diverse lawyers, and the work that they will do. What is their role going to be as we continue in the 21st century? There's lots of discussion right now about our changing democracy. What advice do you have for lawyers, new burgeoning lawyers, as they are taking on all of the challenges that we face right now as a nation? What kinds of encouraging words do you have for them about ways that they can ensure that we make our democracy stronger and more effective?
Well, I hope everything I've said up until now has been encouraging to you. But if you see a need, you're not going to be successful alone. But if you get together with like-minded people, that's why I think the Immigration Project of Chief Judge Katzman is so inspiring. And people who care and get together, they can make a difference.
One of the questions that we got from the audience, because we gave people an opportunity to give us some questions a little earlier, also deals with changing our democracy. And one of those questions was, if you could take a magic wand and just single-handedly make one change to the Constitution, what would that be?
It's easy. I was and remain a proponent of the Equal Rights Amendment. And why? People say, haven't you gotten to the same place by decisions under the Equal Protection Clause? My answer is, maybe so. But when I take out the Constitution and show it to my 3 granddaughters, I would like to be able to point to the statement that men and women are citizens of equal stature as being a basic premise of our society, not something that we extract from the Equal Protection Clause that became part of the Constitution in 1868, when some states hadn't yet enacted Married Women's Property Act. I would like it to be there as a basic statement that women really do count among the we people, which of course they didn't in the beginning. We the people was a very select group. They were white, they were male, and they owned property. But as I see, the genius of the Constitution is that over the course of the centuries, that notion of who comprises we the people has expanded so that the people left out in the beginning are now there. People once held in human bondage, Native Americans were not part of the political constituency. And then half the population, women. I think Thurgood Marshall once said that the Constitution he celebrates is not the one that was enacted in 1787, but what the Constitution has become in the course of sometimes turbulent decades and centuries.
And looking at changes that might be made, many are curious about the future of capital punishment as being one of the major changes that may be coming. What's your opinion about that? What do you see the future of capital punishment as in this country?
The only comment that I would make is that the incidence of capital punishment has gone down, 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 so that now I think there are only 3 states that actually administer the death penalty. And not even whole states, but particular areas of states. It may depend on who is the district attorney. So we may see an end to capital punishment by attrition. as there are fewer and fewer executions.
One curious question that several people have asked me, and that is, obviously the work that you do, that you've done throughout your career has been amazing, but some have asked me if the justice could do anything else, what might she do?
Well, I've answered that question more than once, and I said, if I had any talent God could give me, I would be a great diva. I might be Jesse Norman or Beverly Sills. Or my dear friend Denise Graves. Sadly, I am a monotone. So the next best thing.
I don't know, Your Honor. I think some of us may feel we have enough divas in the world, and we might prefer you where you are. Before we part, because I'm getting my little hook pulled, because we could go on talking to you for hours. Again, this is a group of students who want to go on and be change agents, who are living in the early part of the 21st century. And if you could give them one or two parting words, I'd love to hear what those are. And it can range from anything to do 20 push-ups a day. And I want you to know, Your Honor, I do my 20 push-ups a day. My husband, though, who's in the back of the room, told me to skip my workout this morning because he said, you're busy preparing for this. And I said, there's no way I'm going to talk to Justice Ginsburg and not be able to tell her I did my 20 push-ups today.
Well, there's time. I do mine between 7 and 8, as I will this evening. And 7 and 8, because nobody else uses the gym at that time. And the other reason is I can watch the NewsHour.
So one or two pieces of advice as they go off. And you should know, when they leave this big room hearing from you, they're going to go off into breakout panels where they're going to get to talk to practitioners about the kinds of lawyering that they're doing, whether it's government service, whether it is doing transactional work, or whether it's doing non-traditional legal work. So what one or two pieces of advice would you give them?
I might borrow from the advice my dear colleague David Souter might have given. He thought it was very important for lawyers to do something, his expression was, outside themselves. Something, as I said before, that would make things a little better, that would help repair tears in the society in which you live. Do something outside yourself.
And with that, Your Honor, we thank you so much for your time and your wisdom today. Thank you so very much.
Oh, it was great.
Thank you so much, Justice Ginsburg and Nicole, for that remarkable conversation and for allowing all of us to eavesdrop on what you were saying. My name is Nancy Lopez, and I'm the Executive Director of the Washington Council of Lawyers. I'm a big fan of music, and I was going to make a Notorious B.I.G. joke, but I'm going to skip it. My husband told me I should skip it. But I usually take Justice Ginsburg's advice on marriage that was given to her, and I'm a little bit deaf to his advice, which sometimes works out okay, because when I wrote to invite Justice Ginsburg to speak, she at first turned us down because the dates that we had selected were dates that she had a conflict. And I said, I am going to ask her to reconsider. And my husband said, no. This nice woman nicely told you no, and you should listen to her. But I was a little bit deaf, and I asked if she would, instead of coming in June when we normally hold our summer forum, if she would join us today, and I'm so glad I did.
Very good, Nancy.
So, our summer forum inspires and equips lawyers and law students to use the law to pursue justice. And I love what you said about getting together with like-minded people, because that is what we are all about. So thank you for joining us. Thank you for the great conversation. And then thank you to GW Law School, to Ave Tucker, to J.S. Saxena, who all helped make it possible for us to have the summer forum here, where more people could come and join us today.